Meridian, Duchesne County, Utah. We're holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. Before I begin, are there any members of the public or interested parties who are here that are not either on the petitioner side or the division side? I am not seeing any hands raised. Is there anyone online?
There's not.
Okay. So let the record show that there are no public or respondents present. So let's take appearance of the council at this time. First of all, the petitioner.
Thank you, Mr. Hearing Examiner Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner OVINTIV USA.
Okay. Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay. Just some housekeeping. This is a continuation of a matter which was initiated in front of the hearing examiner in January. So we do have declarations that were filed by Mr. David Dale and Mr. Christopher Wall in this matter, and we reviewed them before the hearing. So, Division, have you reviewed those declarations, and how would you feel about them being qualified as experts?
Yeah, the division has reviewed the declarations and has no objection to other of those two being sworn into witnesses.
Okay. So they are recognized as experts in their particular field of expertise for this matter. So let me ask, were they sworn in last month, or do we need to do that today?
I believe even if they were, we probably should do it again today, but I don't think they were last month. As I recall, at the start of the hearing, I just made an announcement about the continuance and requested it, and John Rogers of the hearing examiner in January granted it.
Okay.
So, yeah, it's probably appropriate to swear in.
Okay, I see that both gentlemen are online right now. So I'm going to conduct the swearing in, fellows. So if you raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth? Mr. Dale Burr.
I do.
Okay, thank you very much. So they're appropriately sworn. Mr. Mayo, I think you can go ahead with your presentation at this time.
Thank you for that, Mr. Bozet. Just making a note. Apologize for my slow writing. Thank you for that. A lot of the housekeeping's out of the way. Again, this has been pending for a couple of months with just a pin put in it at the January hearing to continue it to today. Before I get too much into the matter, I'll just say the reason for the pause last month was a last minute concern question about whether a mineral owner had been notified properly. But because it was discovered 10 minutes before the hearing, we didn't have time to satisfy ourselves. So we decided the best thing to do was to put a pause on it to this month. Within a couple of hours of the hearing in January, we had confirmed that everything was okay and we were ready to proceed. So not much has happened for the last month in this matter, but we're teed up and ready to go. And the good thing is folks have received lots of notice and have had an extra month to weigh in. So it should give us all comfort when it comes time to make a decision. As has been discussed about, this matter was initially filed for the January docket and was referred to a hearing examiner, Mr. John Rogers. It was continued to this hearing, but the witnesses were granted the authority to appear remotely as they are here today. Furthermore, as mentioned, pursuant to informal agreement of the parties, both witnesses submitted their declaration testimony. That also was submitted in January. There have not been any updates to that because there have not been any intervening factual changes necessitating an update. Both witnesses are here today, obviously, to address any concerns or questions with those declarations that folks may have. The board, and by designation, Mr. Baza, here today, the hearing examiner, has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-6.5 and the implementing regulations found in R649-2-88 and -9A. A copy of this request filed in December was sent by certified mail to the known parties sought to be compulsorily pooled and sent by regular mail to all other production interest owners within the drilling unit at the last known address of record. In addition, the request was mailed to all the relevant federal, state, and tribal agencies as required due to mineral ownership within the drilling unit. In addition, notice of the filing of the request and of the hearing was published in the UN Basic Standard on December 25th, and in the Salt Tribune on December 29th, 2024. On January 8th, the Division of Oil, Gas, and Mining filed a response expressing no opposition to granting the request pending the presentation of evidence here today. And no other objections, despite the fact that there was an additional month of time to object, no other objections or responses to requests were filed here today. As mentioned, this cause involves compulsory pooling of a unit. It is approximately 1,293.72 acres. It's established for the Lower Green River-Wasatch Formation production. This unit is comprised entirely of sections 2 and 11, 4 South, 3 West in Duchesne County. It was established by the board in its order entered on February 23rd, 2018 in clause number 139-150. And I may refer to that as the current order. OVINTIV is the majority interest owner as shown in Exhibit 8 on file and as stated in Mr. Dale's declaration also on file. Mr. Dale's declaration, I believe, is Exhibit 38. Yes. Pursuant to the current order, a copy of which is on file as Exhibit 2, OVINTIV spud and has begun to produce from the Pekepovits UT 1-14 4-3-11-2-1H well. The Pekepovits well spud on May 23rd, 2018, and had a date of first production of October 15th, 2018. I'd like to note for the record that conversion is not applicable in this cause because there were no existing wells at the time of production. Several owners of undivided oil and gas interests in the subject unit and the subject well have refused or failed to lease or otherwise agree to pay a proportionate share of the cost of the wells, including those names identified on page 2 of the request for agency action. In addition, there are several estates to be pooled, as identified on pages 2 and 3 of the request for agency action on file. Although OVINTIV is confident that it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses contained in said leases, there may be additional parties claiming buy-through under those estates who buy-through under certain of those decedents whose estates have not been probated in Utah or are incomplete in distribution as to the subject minerals, such that we can't be certain all parties are incorporated into this development. Pursuant to the board's order entered on December 12th of 2024, the requisite notice of opportunity to participate was provided to any folks claiming through the decedents by publication. Evidence of this publication is on file as Exhibit 40. No responses were received other than the following corrections of note. And these are noted in Mr. Dale's declaration on file as well. Following the filing of the request, OVINTIV was contacted by Tim Shepard, who claimed an interest in the drilling unit buy-through under 2 estates, the estate of Joseph C. Shepard, Tim's father, and the estate of Viola May Shepard, Tim's grandmother. After reviewing the relevant documentation detailing the distribution of both Joseph's and Viola's estates, OVINTIV has determined there is no need to pool their respective estates. Accordingly, both of those estates have been removed via the declarations and will be confirmed as such here on the record today. A couple last minute things. On Exhibit 34, and as discussed in Mr. Dale's declaration, the acreage weighted landowner's royalty to be imposed in this cause is 18.863463,659%. And costs, including the plugging costs, we believe are just and reasonable, and the risks incurred to drill the subject well justify the risk compensation award requested herein. With that, and if there are no questions before I begin, I'll jump into examining Mr. Dale about his declaration.
Let's go ahead and do that.
Okay. Mr. Dale, can you please state your name and business address for the record?
Yes, David Dale with OVINTIV. The business address of 4 Waterway Square, Suite 100, Woodlands, Texas, zip code 77380.
Okay. And Mr. Dale, can you please tell the hearing examiner what your job title is and your responsibilities generally speaking?
Yes, manager for Rockies Land, generally overseeing land work performed on behalf of OVINTIV within the Uinta Basin.
Okay. And I'm assuming that gives you some sort of supervisory role over what's this unit in particular.
Correct.
Okay. Mr. Dale, are you aware of and have you reviewed what's been filed as Exhibit 38, the declaration of David Dale in this cause?
Yes.
And did you execute that declaration or cause your counsel to execute it on your behalf?
Yes.
Okay. Are you familiar with all the allegations contained in the declaration?
Yes.
Okay. And does the declaration as conformed to what's been said here today, does that constitute your full and complete and accurate testimony in this cause?
It does. Yes.
Okay. Aside from the estates of Joseph C. Shepard and Viola Mae Shepard being removed, are there any other adjustments or modifications that we need to note for the record here today?
No.
Okay. Last question then for you. In your expert opinion, as an expert in petroleum land management, do you believe the terms and conditions of the joint operating agreement submitted as Exhibit 33 are fair and reasonable and should govern the operations in this matter?
Yes, I do.
Okay. With that, I don't have any further questions for Mr. Dale, subject to any confirmation.
Okay, the only question that I had on review was, we noticed that the percentage of compulsory pooled interest in this case is 7-point-something%. That seems a little higher than the poolings that I've reviewed in the past. Is there a reason for that, Mr. Dale?
And I guess I'd have to see, Mitch, I need to see those exhibits because unless I revised them, I thought it was a lower percentage than 7%.
7 is what the updated one said too.
Yeah, the updated one says 7%. It is, let me see if I can show you this full screen here. And David, I don't know if you can see the screen at all.
I think the table was
Yeah,
on
that's-
Exhibit 8.
No, I can't see your screen. I guess that's something to look at because I know that we had some preliminary exhibits and then we revised them, but I thought that the revision took the unleased percentage down to more like 3%. I think I made that error because I didn't account for all the leases that were taken between the original deck and the original exhibit preparation. So Mitch, I need to confirm that.
Okay. Do you, it says it's not allowing me to share my screen. I made a mistake. It is now. There's a PDF. Mr. Dale, is there any ability to confirm that? Say if we needed to confirm that and put a pause on it here in the next 30 minutes or so?
Yes.
Yeah. I'm not sure how, to be honest, I'm not sure that it's much more than a curiosity. That it needs to be continued. But
the curiosity was about the 7%. But if he's saying it's actually down to 3%, then that changes.
Well, and the truth is, if it's down to 3%, then obviously there's been a mistake in the exhibits not getting updated, and that's something we would need to fix anyway. But what I heard, I want to put words in your mouth, is you're not certain of the percent being pooled. Is that right, David?
That's correct. I need to go back and confirm what the correct number is there on the exhibit. But to answer your question, Mr. Baza, there's nothing unusual or unique about this particular unit. It just so happens that, they're somewhere between 3% and 7%. And in general, in Utah, we find that I'm just going to give you a rule of thumb. Usually when we commence our pooling efforts, there is 5, 6, 7% that remains unleased. But since we have the mechanism to force an election from these parties and kind of force their decision to either participate or not, we do end up getting, roughly half of that in leasehold. And so that's the confusion here is I must have made a mistake on my initial exhibit and the final exhibit, but there's nothing factually unique about this particular ownership in this exhibit or in this unit.
Okay. I was just used to seeing numbers more like 1, 2, 3%.
Correct. Yeah, 7 would be high. So let me go back and confirm that. And yes, Mitch, I should be able to knock that out within these hearings.
Okay.
Okay, thanks.
Division, do you have questions? Please.
Based on the discussion that was just had, nothing specific, just if the number is drastically different, you just update that exhibit. But just for Mr. Dale, based on the continuance we have in this matter and whatever the outside issue is, I just want to confirm the record. So there's no need to update anything in your affidavit or any changes.
No, the concern was state highway runs through these lands. State highway runs through these lands, and in some cases, TxDOT will own the minerals under, or not TxDOT, UDOT will own the minerals under public highways. But in this particular case, there were some comments within the title opinions, but we reviewed all the historical title opinions, looked at the deeds. I even kicked it to a title professional, and I think even Mitch looked at. We all agreed that UDOT did not, in fact, own the minerals, and so that was my concern: is if we had a FFSL ownership in here, and that was confirmed to be untrue, and we can proceed forward.
All right, thank you. Yeah, the division has no further questions.
Thank you. I think that's all of our questions, Mr. Dale. So Mitch, you can probably proceed.
Perfect. I will move on to Mr. Wall. Chris, are you there and can hear me all right?
I can hear you.
Okay, perfect. I'm having some technical difficulties here on the computer end. I was going to show a couple of the exhibits for the hearing examiner's benefit, but I may do it kind of informally and just show him my computer screen if we have questions and we can kind of walk through them. Mr. Wall, before we begin, can you please state your name and confirm that you have the same business address as Mr. Dale?
Yes, my name is Christopher Wall. That's W-O-L-L, and I do have the same business address as Mr. Dale.
Thank you. And can you please state your job title and your responsibilities generally and as they relate to this issue?
Yes, I'm a reservoir engineering advisor for OVINTIV with jurisdiction or authority over this drilling unit as well as others in the Uinta Basin.
Okay. Now, are you familiar with what's been filed as Exhibit 39? This was filed last month in this cause, the declaration of Christopher Wall.
Yes.
And have you reviewed all the allegations that are contained within that declaration?
Yes.
Did you execute the declaration or cause your counsel to execute it on your behalf?
Yes.
Does the declaration constitute your full and fair and complete testimony to be considered in this cause today?
Yes.
Okay. Is there anything you would like to add or clarify before we move on to division or hearing examiner questioning?
No.
Okay. Mr. Baza, after I ask him a couple more questions, help me understand how you'd like to proceed with the exhibits, if at all.
Okay, one issue I had was on Exhibit 34.
Okay.
Is the calculation of the average weighted royalty. My copy of that got cut off, so I don't see the actual number on the final page of that exhibit.
I can show you if you'd like. This is the exhibit that's up flat, and Andrew, maybe you can check that with it.
Okay.
It's 18.86.
That's right. And I apologize again for the inability to share. By the way, it says I'm sharing.
It does. It does. The fix that I've found is to restart your browser and rejoin the meeting. So if you want to do that, we can do that.
I think we're close to being done. If
Yeah,
everyone else
I
here would
think
like
we're
me to.
Okay.
Then on exhibit 36. Oh, well, let me just show you. Much of the information got truncated somehow. on both the left
So
and the right.
frustrating. I'm sorry.
So, I guess I'm just curious, what am I missing?
Well, on the left-hand side of the screen, what's missing from your page is essentially an index.
Okay,
It identifies different colors and different shapes and says this is a vertical well, this is a horizontal well, etc. Really, I think the meat of what you got on there is what you need to see, and that's that there aren't any wells in this unit before the drilling of the Pekepovits, and there really weren't that many horizontal wells that close to it either.
okay.
And that's kind of the point of this exhibit, I guess, subject to Mr. Wall confirming. The point of the existing wells exhibit is to show kind of how much well control you have and if there's any knowledge, that kind of stuff. Is that fair?
That is
Sure.
correct, yes.
And then just on the right-hand side of the screen, if you're missing anything on that, it's essentially just
I think it just lists the wells.
that's right. Okay.
Okay. Exhibit 37. Again, the left and the right got cut off, so.
I think you have that entire exhibit though.
Oh, is it?
I think so. I can't see the left side, but maybe there's,
It just, yeah. You can see there's stuff.
oh yeah, you did just miss a little bit on the left.
Yeah. I'm wondering if Mr. Wall can just kind of walk us through that verbally.
But yeah, is there any chance you have the exhibits available, Mr. Wall? Because I'm having difficulty showing that here on my screen. For the Pekepovits that you could pull up,
This would
He
be,
just shares them and then, yeah, it'll show up.
and you could share them from your screen if you've got them. I think I emailed them to you yesterday maybe.
this will be number 9 of his declaration.
Yeah, let me see if I can pull them up.
Sorry about that.
Are your copies any better than this?
Yeah, we have,
Oh,
because we just look at them visually.
okay.
We'll fix that.
Oh, man.
You might need to hit stop sharing. If it says you're sharing.
It
Okay.
did. And it went away, so maybe it's not.
Sorry to complicate things.
Okay.
No, it's
No,
not
we
your
can figure it
fault. It's,
We have the room till 5, so.
no. We don't want to go that way.
No.
So I have this.
And if you go to
There
the
you go.
very last page, oh, there you go. Yep.
So maybe just walk me through that and summarize it for me. I know you've already submitted your declaration.
He's missing on his printed copy, Chris, so you know what's missing. Basically, pre-spud risks, all it says is D risks. So everything to the left of that is cut off from his page. So it's hard to really understand. If you can kind of walk through what this shows and help justify the risk compensation.
Okay, no problem. So what this exhibit should walk through is some of the risks that we encounter when we develop oil and gas wells in the Uinta Basin. So starting at the top, we look at geologic risk, which is, we have this stratigraphy of the zones that we develop, have a lot of clay in them, and clay can be challenging as we're drilling the wells. They cause hole stability issues, so we get stuck or we can't run our tubing or casing to the bottom as we would like. And then while we're drilling them, that's the drilling and operational challenges. We have to control our costs, and if we don't have a lot of example of wells that we've drilled in the past, we have a higher probability of blowing through our budget, basically, because we just don't know how things are going to drill in the area. Again, those high clay content of those intervals, causes operational issues. And then some recent examples, we run through some of those. We had some collapsed casing during the Black Air and the Bruce 42H recently in 2024. We've had some cementing challenges where we lose lateral footage, and the Tomlin 46 is an example of that. We also shear some BHAs, which is a bottom hole assembly, basically tools that we use to drill, that we have to call well short. And the Abbott 46H back in 2022 is an example of that. After that, we walk through some commercial challenges. So always oil and price uncertainty is something that we have to weigh as a risk. And then future refinery and rail car availability is very important to the basin. Being able to get our product to market is always a challenge and is a risk that we encounter. And then in particular, we walk through actual occurred risks during the Pekepovits 1H. And luckily for us, there weren't many challenges that we encountered that we couldn't overcome while we drilled and completed this particular well.
And obviously all of that goes into your justification for risk penalty, correct?
That is correct, yes.
Thank you for doing that for me, Mr. Wall. I appreciate it.
Yeah, no problem.
And Chris, can you share, Mitch, I'm good to go. If you want to go up 3 exhibits, Chris, and we can go over the working interest. I've been able to confirm that.
Oh, cool.
Well, that is a different exhibit than what's been filed. So I think that might be the confusion. I think maybe we got sent the updated exhibit to file, but it wasn't the updated exhibit.
Yes, I think that's the case. Yeah, I think what happens in this is I looked at our existing well deck, and then we have an unleased mineral report, and comparing this with this. What happened, Mr. Baza, is when we started this force pooling action, yes, there were roughly 150 acres that remained unleased within this DSU. And we had leased some of that, and we had to update the deck partially, but not fully. And so when I sent this working interest sum to Mitch, it showed roughly 7% being compulsory pooled, but that was not accurate because we had at least another roughly 4%. So the deck just needed to be further updated. This is accurate for this well, and it is only 3% that we're pooling roughly.
So let me ask, other than the numerical adjustment, does it materially change any of the statements in your declaration?
No.
Okay. So what I would ask, Mitch, is just prepare a revised exhibit that we can submit when we report to.
Perfect. And I'll actually probably just file that today, and then we'll have it available and you can discuss it. But it's probably appropriate to ask the board to admit it because we don't have it here today necessarily to have you admit. So that makes sense.
All right.
I'll work with the council.
So division, have questions for Mr. Wall or Mr. Dale?
We have no questions for Mr. Wall.
Okay. All right. I think we're at the point then to take closing statements. And I know we have the file division statement from last month. So I guess we'll start with you, Mr. Hanson.
Yeah, we filed our response last month. After reviewing the request and the associated exhibits, and then listening to the testimony today, the division has no opposition to this request for agency action.
And you're comfortable with the requested risk percentage?
Yes.
Thank you. Mr. Mayo, I guess we'll end with you.
Yeah, quick before I close, it's probably appropriate to move for admission of exhibits. At this time, we have in this cause already filed a corrected exhibit 7 and 8. So this is going to be a little confusing, but we're going to do our best. I'd like to move for admission of exhibits 1 through 6, corrected exhibits 7 and 8 that are already on file, and exhibits 9 through 41. In addition, I'd like to move for provisional admittance, in case the board hasn't, of second corrected exhibit 8, which will be filed here today.
Okay. Any objections? Yeah, we'll accept all those.
Okay. As far as closing, I'd like to apologize. This matter was clunky from the beginning. It has been anything but smooth. We really appreciate the efforts. It certainly didn't go the way that we are used to it going, and we appreciate everyone's flexibility and ability to work with us. All that being said, full notice was provided. In fact, double notice was essentially provided in this cause. There were no objections or protests, and the parties who have contacted us, they've all been removed appropriately from being pooled in this cause compulsorily. All the statutory and regulatory requirements have been satisfied, and we believe the relief requested is fair and reasonable and warranted. And on that basis, I'd ask you to recommend approval of the request to the board.
Okay. Well, knowing that we've had no objection, no response, and no input from any other parties, I'm going to find in this case that OVINTIV has provided sufficient notices of opportunity to the non-consenting owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with this well, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that it is entitled to forced pooling of the named interest and other relief requested in the request for agency action. So, Mr. Mayor, I'll ask you to button this up with a proposed order so that we can address this in front of the board next week.
I'm happy to do that. Because of the delay last month, I've actually got an order that's along the way. I'll try and finalize that today and hopefully get the corrected exhibit 2, corrected exhibit 8, and the draft order out to council today for review.
And I will plan to present the findings and conclusions to the board at their regular schedule here. So any other comments on this matter before we close? All right, we'll adjourn this proceeding and move on. Thank you so much, Mr. Mayor.
Thank you, Mr. Boz. I appreciate it.
Are you done, Martin?
I have.
Mr. Boz, if we could take a 5-minute break and so I can just set up.
Let's do that.
We'll test your sharing capability.
Yes.
Every.
You know, Well, good morning, everyone, and welcome to our hearing examination this morning. My name is John Baza. I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, February 19th, 2025. This is the time and place for the hearing examiner's proceedings for docket number. Sure, I've got the right one here. Docket number 2025-015, cause number 132-72, in the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interest of certain non-consenting owners in the Marie 15-22-15-3-3W-UW, the McKinnon UT 14-22-3-3-22-15-5H, and the McKinnon UT 14-3-3-22-15-7H wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formations, comprised of all of sections 15 and 22, Township 3 South, Range 3 West, U.S. Special Meridian, Duchesne County, Utah.
Rolls off the tongue.
Yeah. So we're holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. And as we begin, are there any members of the public or respondents present that wish to comment? Are there any online?
No.
Okay. Seeing none, let the record show that there are no public or respondents present at this time. So I will take appearances of counsel.
Fred McDonald of Counsel Lear and Lear on behalf of petitioner OVINTIV USA Inc.
Thank you. And the division.
Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining. I also have division experts Peter Pankey and Colton Goodrich with me.
Okay, thank you. So to begin with, I've received declarations from Mr. Peter Burns and Mr. Christopher Wall, and I've reviewed them before this hearing. Does the division have any objections to either the declarations or the declarants being qualified as expert witnesses?
No objections.
Okay. They are recognized as experts in their particular field of expertise for this matter today. Mr. McDonald, I see that those witnesses are present. Is it okay if we go ahead and swear them in at this time?
Yes, please.
Okay. If both of you would raise your right hands. In this matter, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you so much. Both witnesses are appropriately sworn. So Mr. McDonald, go ahead with your presentation.
Thank you, Mr. Baza. And for the record, Mr. Burns is being recognized as an expert in petroleum land management, and Mr. Wall is being recognized as an expert in petroleum engineering for purposes of this cause. I'd like to first confirm that you received Exhibit 50, which is simply all of the proofs of the mailing of the request to the compulsory pool parties that we received. That was filed yesterday.
And Julianne sent that email out yesterday as well.
Okay, great. The board, and by designating Mr. Paz as the hearing examiner, has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R649-28A and 29A. A copy of the request was mailed certified mail to the known party sought to be compulsory pooled and mailed regular mail to the other interest owners in the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. And that included to the Ute Indian Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, and the Vernal Field Office of the Bureau of Land Management, which serves as the technical advisor to the BIA due to tribal and allotted mineral ownership. And also to the Utah Department of Transportation and the Division of Forestry, Fire, and State Lands due to the state UDOT mineral ownership within the drilling unit. In addition, notice of the filing of the request and this hearing was also duly published in the Uinta Basin Standard on January 29th, 2025, and in the Salt Lake Tribune on February 2nd, 2025. On February 10th, 2025, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request. And finally, no other objections or responses to the request were timely received. I'm going to summarize here, and again, Mr. Boz, I'll try and go through some of these exhibits for your reference as well. This cause involves the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 15 and 22 of Township 3 South, Range 3 West in Duchesne County. Both sections are regular governmental sections, and accordingly, the drilling unit is comprised of 1,280 acres. As shown on Exhibit 3, which is on the PowerPoint there, this drilling unit is approximately 2.5 miles northeast of the Bridgeland community in Duchesne County. The drilling unit was originally established on a pilot basis for Upper Wasatch production by the board's order entered in cause number 139-110, as subsequently modified by the board order entered in cause number 139-117. Both of those orders were subsequently vacated and superseded by the board's order and in cause number 139-134, which established the drilling unit as to the entirety of the Lower Green River-Wasatch Formation. True and correct copies of the 139-110 and 139-134 orders were collectively submitted as Exhibit 2 in this cause. And the 139-134 order outlines the history of those prior pilot orders. As reflected on Exhibit 4, in paragraphs 14 through 17 of Mr. Burns' declaration, Newfield drilled and OVINTIV operated the following wells on the drilling unit. These right here are the 3 wells that are at issue. And on Exhibit 8, wrong one. Yes, sorry, these 3 wells are the wells at issue. The Marie well was drilled pursuant to the 139-110 order as modified by the 139-117 order, with first production from the Upper Wasatch on September 17, 2014. The McKinnon 5H well was drilled pursuant to the 139-134 order, with first production from the U.S.M Butte on June 22, 2016. And finally, the McKinnon 7H well was likewise drilled pursuant to the 139-134 order, with first production from the U.S.M Butte on June 25, 2016. However, for some unknown reason, Newfield never sought compulsory pooling relating to these drilling units in these 3 wells. All 3 wells have reached 100% payout, but have not reached 300% payout. As reflected on Exhibit 5, in paragraph 9 of Mr. Burns' declaration, there are 34 different oil and gas tracts in this drilling unit, including tribal and allotted owned mineral tracts administered by the Bureau of Indian Affairs, and the UDOT tract administered by the Division of Forestry, Fire, and State Lands. As reflected on revised Exhibit 6 and paragraphs 10 and 11 of Mr. Burns' declaration, Newfield and later OVINTIV was the majority working interest owner in the drilling unit or the designated operator under a wellbore only farm out, approximately 99.78%. And the other 2 parties whose aggregate working interest is 0.04%, they're subject to a joint operating agreement, thereby voluntarily pooling their interests and which cover the consequences of their elections in these wells. There are 32 specific parties to be compulsory pooled and declared as non-consenting owners in the subject wells after my motion to modify the request, which I'll address shortly. They are identified on pages 2 and 3 of the request in paragraphs 18 through 50 of Mr. Burns' declaration. In the interest of brevity, I ask that you take administrative notice of those portions of the pleadings already of record and we are reciting all those parties now.
Oh, I'm happy to do that.
After filing Mr. Burns' declaration, it was discovered that after the request and the exhibits were filed, William Lewis Spackman had in fact leased to OVINTIV. As a consequence, OVINTIV moves to amend the request to eliminate him from being compulsory pooled, and Exhibit 41 will be no longer required and will not be submitted for admission into evidence. I will note that revised Exhibit 6 does account for that deletion. This was filed yesterday. As evidenced by Exhibits 10, 11, 15 through 18, 21 through 27, 29, 31, 33 through 36, 39 and 42 through 44, and is addressed in Minister Burns' declaration relating to those exhibits. The requisite notice of opportunity to participate in these 3 wells was provided and received by the parties identified therein, but none have formally or timely responded. As evidenced by exhibits 19, 20, and 42 through 44, and is addressed in Mr. Burns' declaration relating to those exhibits, Jana Lee Griffin and Sherilyn Olson were sent and received the notices of opportunity to participate in the subject wells, and they timely responded by returning executed elections to participate, but they did not execute AFEs for the proposed joint operating agreement or provide any written objections to the terms of that joint operating agreement. Nevertheless, OVINTIV is elected to treat them as consenting owners, but they're still required to be compulsory pooled, and the terms of the proposed joint operating agreement still need to be imposed upon them. As evidenced by exhibits 7 through 9, 12 through 14, 1 to 8, 30, 32, 37, 38, 40, 42 through 44, and replacement exhibit 45, and the paragraphs in Mr. Burns' declaration relating to those exhibits. The parties identified therein, if known, were also sent the notices of opportunity to participate in the subject wells to their last known addresses, but they were returned either as undeliverable or as refused. Pursuant to the board's order entered on January 27, 2025, all of those remaining parties were also provided notice by publication in the Uinta Basin Standard on January 29th and February 5th, 2025, but none of them have formally or timely responded as well. As reflected in the revised Exhibit 6, the aggregate gross working interest to be compulsory pooled is 0.175028%. In addition, OVINTIV believes it has leased all such successors and voluntarily pooled their interest pursuant to the pooling clauses relating to the decedents that are listed in the request for agency action, but without those estates being properly probated and distribution made in accordance with the law, we can't be certain of that. So we also requested that anybody claiming by, through, and under those estates that have not leased or have not participated also be compulsory pooled. Notice to those parties was also given by publication in the same manner as I have described. Now, with respect to those decedents, U.S.M was listed among those as being one of the decedents whose estates needed to be compulsory pooled. But as reflected in paragraph 53 of Mr. Burns' declaration, OVINTIV has confirmed his estate was probated and all his successors are in fact leased or are participating. Consequently, I will also move to amend the request to eliminate anyone claiming by, through, or under the estate of U.S.M from being compulsory pooled. Replacement Exhibit 45 in this cause is a true and correct copy of the affidavit of publication of the notices that was received from the Uinta Basin Standard. As reflected on Exhibit 46, and I'm just going to turn to the last page here, the average weighted fee owner landowner royalty as of the date of the spud of the Marie well was 18.840877%, and as of the date of the 2 McKinnon wells was 18.819149%. And that's because there was a gap in the difference there between the wells being spud. As outlined in paragraph 59 of Mr. Burns' declaration, as will be corrected by Mr. Burns in his testimony today, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the drilling unit. Their names and addresses were derived from title opinions with effective dates of April 23rd, 2012 as to section 15 and July 26, 2012 as to section 22, as supplemented by a record search by OVINTIV's land brokers and OVINTIV's internal records. As the record will reflect, none of the parties identified in the request is amended today as being compulsory pooled and or is declared as non-consenting owners in this cause, timely filed a response, or have made an appearance today. Consequently, pursuant to Utah Administrative Code R641-113-100 and R641-108-400, OVINTIV moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion.
Yes, I think that's traditionally how we've done this, so I'll go ahead
All right, thank you.
and rule on that.
All right, as reflected in Exhibit 47, in paragraphs 4 and 5 of Mr. Wall's declaration, the costs incurred in the drilling of the subject wells were reasonable and necessary and were in reasonable variance of the AFDs, especially given the difficulties in the Marie and McKinnon 7H wells, which are shown on the following exhibits. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for each of the wells is $75,000. And as shown on exhibits 48 and 49, in paragraph 7 and 8 of Mr. Wall's declaration, the risk assumed at the time of the spud of each of the wells is outlined in these exhibits, and the difficulties that were actually incurred in drilling the Marie and the 7H well are shown as well on exhibit 49. With that, that concludes my summary, and I will commence my examination of Mr. Burns. Have Mr. Burns come up. Okay. Mr. Burns, would you please state your name and business address for the record?
Yes, Peter Burns with OVINTIV. I'm a land advisor, and OVINTIV's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
What is your current position with OVINTIV, and how does it relate to this drilling unit addition?
Yes, I'm currently a land advisor over the Uinta Basin with responsibility over this drilling unit, among others.
All right, would you please state the corporate and bonding status of OVINTIV for the record?
Yes. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to New Fuel Production Company and by merger of OVINTIV Production, Inc.
All right, and has there been a change in recently that please advise the division and the hearing examiner about that?
Sure. Yes. So on January 22nd, 2025, OVINTIV closed the sale of its Uinta Basin assets to 4 Point Resources, LLC, which was retroactive to being effective as of October 1st, 2024. However, Newfield and OVINTIV owned and operated the subject wells at all times relevant to this cause, and as such, OVINTIV remains the petitioner.
All right, would you please confirm for the record exhibits 3 through 40, 42 through 44, and 46 were prepared by you or OVINTIV personnel or contractors with your review and input?
Yes.
Could you also confirm for the record that replacement exhibit 45 is an official business record of OVINTIV?
Yes, it is.
All right, will you also confirm for the record that you have read and can confirm that all the statements made in your declaration are true and correct? Or if any modifications are required, please state them on the record at this time.
Yes, I believe all true and correct, except for 2 corrections that we're going to make here. Paragraph 59 does require a change. The effective dates of the title opinions were April 23rd, 2012 as to section 15 and July 26th, 2012 as to section 22. Also, paragraph 51 should be stricken as a result of William Spackman leasing to OVINTIV.
All right, finally, is it your expectation that the terms and conditions of the joint operating agreement submitted as exhibit 44 are fair and reasonable and consistent with those executed by the other working interest owners in the drilling unit, as outlined in paragraph 55 of your declaration, and also that those are the same terms that are commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes, I do.
All right, Mr. Baza, that concludes my examination. Mr. Burns is open for questions from you in the division.
Okay. The only question I have is one more of curiosity. I noticed that a lot of the offers that were mailed out came back undeliverable and returned. And that tells me that, you know, they don't have an adequate mailing device or whatever. So if the non-consenting owners are to receive their weighted average landowner royalty, how do they get paid?
Mr. Burns, you want to answer that?
Sure. I mean, we'll continue to try to do, some digging to see if we can find a better address. It'll get put into their average weighted royalty will get put into suspense. And eventually that does get us cheated to the state. But, to some degree, we're reliant on the last best address in the county records. And, so that's all we have to go on, really.
And yes, what they suspend in accordance with the statute is required, and then after 3 years, it goes over to the unclaimed property act.
Okay. Again, thank you for that. I just wanted to know. Division, do you have questions?
Yes. Mr. Burns, good to see you again. Do you still work for OVINTIV, or are you with the new company?
I'm still with OVINTIV.
Okay. And then I have a similar question. Well, it's not that similar, I guess. When OVINTIV took over for Newfield, was that just a name change, or was that actually a different group of people, a different corporation that took over?
So Newfield and Encana merged together. But the Newfield name remained until we changed the collective company, then changed its name to OVINTIV in early 2020, I believe it was. So it was really the same people from Newfield to OVINTIV, but now it will be a completely separate group, 4 Point Resources out of Denver.
Got it. Thank you.
Sure.
Were you with Newfield before the name change?
Yes, I was.
All right. I have some questions about the timing of all this. Looking at page 6 of the request for agency action, it lists the 3 wells here, the spud dates, and the date of first production. So for example, the Marie well looks like the date of first production was way back in September of 2014. Is that correct, Mr. Burns?
For the Marie. Yes.
So for those parties that you seek to compulsory pool today, when were they first contacted about these wells?
So I was not working this asset at the time. I mean, I have to assume that Newfield at the time tried to lease as many as they could at that time prior to drilling those wells, but I can't say for certain. But again, as we've kind of said in the past, if they were not contacted previously, that's what our effort is here, to try and go back and clean up and make sure that everyone has, ample opportunity to lease or participate.
Have you seen any documentation indicating that the mineral owners were contacted prior to October of 2024?
I have not.
All right. I guess the overarching question would be, how long is too long to wait to contact these mineral owners? I mean, we're at 11 years on the Marie well. Does that seem reasonable to you?
I mean, that is a long time. However, I will say, if they lease or they participate today, they still it all goes back to first sales. So they're in the well from date of first production. And also at this point, there's no risk anymore. They can see public records, see what the well has produced, and understand that, there's 11 years worth of production and revenue associated with each of these, well, the Marie well in particular.
Do you think 20 years would be too long to wait?
Yeah, double the time. Yeah, that's a long time.
I just wonder if does it come to a point where someone during their lifetime just never receives the benefit of their mineral ownership? I guess that's the concern that we have.
Yeah, I think that's justified, but we are trying to fix it here by trying to give everyone notice. You know, and to Mr. Boz's point, there is some, you know, degree of responsibility on these owners to understand that they own and have, you know, better access to an address within the county records or otherwise, so that we can contact them to get them to give them an opportunity to lease or participate.
And your response to the question of why this took so long would be what we've heard in prior proceedings, that there's just a backlog of work.
Yeah, I was working in a different asset for Newfield at the time. I mean, when we couldn't find people, I believe they just opted to carry this interest. And now we are working through this backlog the last, 18 months, 2 years to try to clean all this up and give everyone proper notice.
Yeah, that's all my questions. Thanks, Mr.
Yeah, I
Burns.
was gonna redirect to Mr. Bosman, but if you want to ask your question first.
So along the lines of what Mr. White talked, and you answered, said if a party came to you today, that they would have some opportunity to lease. But didn't we just do an order of default against them at this point?
Right, because they were given the opportunity through these notices and they didn't respond to it. And that's part of what I'll argue about. But what I wanted to redirect Mr. Burns was, and getting to this issue of 11 years is, Mr. Burns, aren't a lot of the people that are named actually people that you discovered might be heirs or somebody claiming through decedents that still show up in the records?
Yeah, and that's the issue here too, is like there's a lot of unprobated estates, so we have to do, significant heirship research to try to identify who might be an heir. And without that conclusive determination by a Utah court, we can't be certain.
So you've had to hire people to dig out and try and find out who successors might be, and that takes some time as well, right?
Yeah, I mean, I don't remember the exact date that we started this work on the Marie McKinnon, but it's likely over 12 months we've been digging into this.
And again, even 11 years later, if they wanted to participate, they would only have to pay their 100% share of costs, even though the well is produced for 11 years. Is that right?
Yeah, I mean, so they're in the money from day one to day, basically.
So it's actually to their advantage that there's been that much production to know, and they still have the opportunity to come in at 100%.
Yes.
Yet they didn't elect to make that decision by virtue of the notices and the publication.
Yes.
That concludes my redirect.
Thank you. Any other questions at this point? All right. So I guess we can move on to your next witness.
All right, thank you. Mr. Wall,
Yes, sir.
give us a second here. There we go. Could you please state your name and business address for the record?
Name is Christopher Wall. That's WOLL. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
Well, what's your current position with OVINTIV and how does it relate to this drilling unit?
I'm a reservoir engineering advisor for OVINTIV with jurisdiction and authority over this DSU as well as others in the Uinta Basin.
All right, I'm going to ask you to confirm. I'm showing, hopefully you can see the screens, exhibits 47, 48, and 49. Were they prepared by you or OVINTIV personnel with your review and input?
Yes.
Would you confirm for the record that you have read and can confirm all the statements made in your declaration are true and correct? Or if you
Yes.
require additions, please state them at this time.
Yes, and no changes at this time.
All right, turning, is it your expert opinion that the actual cost of the wells at issue reflected in exhibit 47 were fair, reasonably, and necessarily incurred?
Yes.
Is it also your expert opinion that the subject wells were economically feasible to drill, as that term is utilized in the 139-110 and 139-134 orders?
Yes.
Finally, is it your expert opinion that the risks that are shown on exhibit 48 and 49 justified the imposition of a 300% risk assessment award and is fair and reasonable under the circumstances of these wells.
Yes.
Mr. Boswell, that concludes my examination of Mr. Wall.
Okay. I don't have any questions for Mr. Wall. This division.
Mr. Wall, I know it's in your declaration, but can you outline the 300%, the 300% penalty and the reasons for that?
So I think, under the JOA that we place out there plus industry standards, 300% payout is reasonable. And our exhibit 49 outlines all the risks that the company, or any oil and gas company for that matter, does undertake when we invest in developing oil and gas wells. I can go through every single one of them, but I think for brevity, I would just point to these particular wells in question. The Marie was a very, very expensive well. It was drilled in 2014. And you juxtapose that with the McKinnon wells, which were 2017 wells, vintage wells. And you can see in that particular time span, we, as an industry and as OVINTIV, we're able to advance our understandings on how to drill these wells more effectively and efficiently and also cost effectively. So even though we still had problems and outside of just operational issues, we still have to carry the burden of risks on the commercial side, which makes this industry very risky, and which is why the industry really would like the 300% payout penalty in the instance where we have parties that do not participate at the start of these projects.
Okay. But again, you don't know if they had an opportunity to participate when these projects started.
That's a better question for Mr. Peter Burns.
Very good, very good. And his testimony will stand on that. The Marie well, it was quite a bit more expensive. Can you help us understand why? That almost looked like it was more than double.
Yes. Vintage plays a role. So 2014, Upper Wasatch, a deeper target, not commonly targeted at that time. So when I look back through the records to understand really what happened, I was expecting to see sidetracks and whatnot, but there wasn't. This was one of the first wells that the rig drilled in the basin, so it moved from another area. I don't know, and I don't have in the record where it came from, but usually it would be outside the basin. So it's very costly to move a rig. It's a lot of equipment, very heavy, a lot of permits that are associated with moving equipment like that, especially across state lines, to get into the basin. So that well was burdened by those costs. So that automatically increases it. That well in particular took well over 30 days to drill. So if we're spending, a lot per day just to drill, holding a rig on there for over 30 days is going to drive up the cost. And that's where a majority of the cost overruns come from. The other thing that, being one of the first wells in the area, we tend to, or OVINTIV tends to put a little bit of science dollars in this. So there is quite a bit of cost associated with running extra tools such as logs and whatnot, so that we have some science. And that also was one of the reasons why this well is very expensive.
Okay, thank you.
Okay, no other questions?
No, sorry, I should have said that. No more questions.
All right, well, I think having gone through your witnesses, Mr. McDonald, we're ready to take closing statements. Division, you filed a response to the request for agency action. Have you heard anything based on the answers to your questions? Has that changed at all?
No, we don't oppose the granting of the request. We do believe that OVINTIV has met the statutory and rule-based guidelines. As outlined in the division's response, we do have concerns about the significant amount of time that elapsed between the production dates for these wells and what appears to be the first attempt at contact to the mineral owners in 2024. Perhaps, as Mr. Burns testified, there was an earlier attempt, but there's no evidence of that. The division's concern, however, is that, you know, these people are mineral owners, and you have a decade go by where they're not aware of what's going on with their minerals. They're not provided notice. I'm sensitive to what Mr. McDonald said in, you know, the points made in the redirect that these people will get the benefit eventually if they're found, if they're still alive, you know, but it's that delay that causes us concern. And perhaps that's something that needs to be addressed with the legislature or before the board. But as far as the actual granting of the request, it does appear that they met the requirements.
Is there a recommendation in there that I can give to the board on how to proceed?
I'd probably want to counsel with the division and Mr. Haynes about a specific recommendation, but my thought would be this could be solved if there were specific deadlines, either statutory based or rule based, that said that these people have to be contacted by a certain time after spud or first production, something like that.
I suspect we might hear from Mr. McDonald.
Yeah. And again, it's not something I vetted. It's just the concerns that something this old raises, and not council's fault. We'd love it if they could move a little faster, but
Yeah, I'm sure a lot of people would.
I'm sure they would.
All right, Mr. McDonald, your turn.
Thank you, Mr. President. First, we need to get the exhibits admitted. I'd move for admission of exhibits 1 through 40, 42 through 44, replacement exhibit 45, and exhibits 46 through 50, as well as Mr. Burns and Mr. Wall's declarations.
Any objection?
No objection.
So, did I get them all?
Yes.
Okay, keep me online. Okay, in trying to address that, I mean, obviously, the company's concerned about the fact that it's been this long. And we can't explain necessarily why Newfield didn't seek compulsory pooling back 2015, 2016. But I will tell you, again, if you look, there are, what I say, 32 people to be compulsory pooled that equal 0.1 or 0.1% total. And a lot of those people were discovered only because the company went in and tried to find who the heirs were, contacted people, got heirship affidavits to find all this. My problem is there's a responsibility when you are a property owner to know what your property is. That's why we have county records. If you move, you should notify somebody. If there's a decedent, then you're required to probate that and prove up your title and who you are. So a lot of this delay comes from that problem of trying to track all these people down. And you will see this today with the amount of people we have in other compulsory pooling actions. Now, to OVINTIV's credit, they're trying to clean all this up right now. And you've seen that some of the ones that have come recently are the more recent wells where they haven't found anybody. They're going back now, and these are hopefully the last few that go back in date trying to clean it up and get it all the way done. So while I understand the term and concern about the time period, if that's going to be the recommendation, then there's got to be a recommendation to mineral interest owners to keep their records current in the county records or provide information to the companies about their claim of interest. Because otherwise it's very difficult even for the companies, and I will tell you as a title examiner, that it's very difficult to try and find these people through the internet. I mean, when we send these things out and they're on claims, listen, we've been looking at the internet, we've been looking at different sites, trying to find all these current addresses. And what happens is you mail it to one address and it says they moved. You send it to that new address and then it says they moved again, or that address, there's no more forwarding information on it. And it's very difficult to try and find these things. Not to say that that isn't a valid concern about the time. The company has that concern as well. But that's why they're here in front of you today, trying to clean all this up to this point. The final point with that is exactly the point I made before. Even 11 years later, when the well has produced and they know that there isn't a problem, they can still come in and paying their percentage cost that it would have been in 2014. Now look at the time value of that money and what OVINTIV carried all that time period without regaining any interest on it. And they still had that opportunity. And the people that definitely got the notification still chose not to respond. That's why we're here today. And that justifies the 300% for this one. With that, that concludes my comments, Mr. Fozzie.
All right. Well, let's see, we've admitted the exhibits. I'm going to make some findings here. Maybe I'll give a suggestion to the division. So, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that it is entitled to forced pooling of the named interest and other relief requested in the request for agency action. And I guess additionally, I know it's a concern to the division. I as well as somewhat concerned with not only the timing, but the discussion we had about this could eventually forfeit to some unclaimed property situation that people can't be found. I would suggest the division stew over that and maybe make a separate presentation to the board about its concerns during a briefing or something like that, and maybe give the board some opportunity to ponder this and figure out if there's a solution that can be done regulatorily or statutorily or something like that.
Yeah, that's well taken. Thank you.
Okay. So, Mr. McDonald, with all of that, I'm ready to present the findings and conclusions to the board next week. Would you prepare a proposed order?
I will, and I'll make sure that council, both for you and the division, has an opportunity to look at it ahead of time.
Thank you so much. Any other comments before we close? All right, let's adjourn this matter. Do we need a short break before the next one? All this one? I just need to rearrange my stacks of paper.
Now,
All right, Carmen, we are ready to proceed. You want to give us a countdown?
You're live in 3, 2, 1.
All right, good morning, still morning to everyone, and welcome. My name is John Baza. I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, February 19th, 2025. This is the time and place for the hearing examiner's proceedings for docket number 2025-017, cause number 132-74, in the matter of the request for agency action of OVINTIV USA Inc. for an order of pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Carl UT 16-19 4-1-20-17-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formations, comprised of all of sections 17, 20, and 29, Township 4 South, Range 1 West, U.S. Special Meridian, Duchesne County, Utah. We're holding the hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. And before we begin, are there members of the public or respondents present who wish to comment in these proceedings? And no one in the room, no one online, I take it?
Correct.
Okay. Seeing none, let the record show that no public or respondents are present for this hearing. So let's take appearances of counsel, first for the petitioner.
Fred McDonald of Council with Lear and Lear on behalf of petitioner OVINTIV USA Inc.
Okay, division.
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining. And I'm here with division experts Peter Pankey and Colton Goodrich.
Okay, thank you. So we have received declarations from Mr. Burns and Mr. Wall. I can see they're both online, and I have reviewed them prior to the hearing. So does the division have any objections to either the declarations or the declarants being accepted as qualified expert witnesses?
No objections.
Okay. So with no objection, they are recognized as experts in their particular field of expertise for this matter. So, Mr. McDonald, your witnesses are present. I guess I need to swear them in, right? All right. So could you witnesses please raise your right hands? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you so much. So with the witnesses being sworn, Mr. McDonald, you are ready to go ahead and begin your presentation.
Right, thank you, Mr. Baza. And for the record, again, Mr. Burns is being recognized as an expert in petroleum land management, and Mr. Wall is being recognized as an expert in petroleum engineering. I want to confirm that that you received Exhibit 66 yesterday, which is simply the return receipts on the certified mailings to the compulsory pool parties. Also want to confirm you received the revised Exhibit 7, which changes, and I'll explain why it changed for that.
Yes, I received both of those.
Okay. Mr. Baza and the board have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R641-2-8A and 9A. A copy of the request was mailed certified mail to the known party sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. And because of the ownership, the Ute Tribe, the Ute Distribution Corporation, the BIA, the Vernal Field Office, the Bureau of Land Management, because there's tribal ownership within the drilling unit. In addition, the notice of the filing of the request in this hearing was duly published in the Uinta Basin Standard on January 29th and in the Salt Lake Tribune on February 2nd, 2025. On February 10th, 2025, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request. Three other parties, Cindy Behunin Harper, Kevin Behunin, and Tracy Behunin Bargerstock, did file timely objections, but all three have formally withdrawn those objections after consultation with OVINTIV and its land brokers. No other objections or responses to the request were received. I'll now summarize the case for you. In this cause, we are seeking compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 17, 20, and 29 of Township 4 South, Range 1 West. As evidenced on Exhibit 4 shown on the PowerPoint here, Section 29 is a partial section resulting from the U.S.M Special Meridian being along its southern boundary. It's also comprised of 4 lots with an aggregate acreage of 33.9 acres. Sections 17 and 20 are regular governmental sections, and accordingly, the drilling unit is 1,313.98 acres. As reflected on Exhibit 3, the drilling unit is located approximately 3 miles southeast of the mountain town site. The drilling unit was originally established for Lower Green River-Wasatch production by the board's order entered in cause number 600-02. A true and correct copy of the 600-02 order was submitted as Exhibit 2 in this cause. The 600-02 order was later modified by the 600-03 order to reduce the heel-toe setbacks of horizontal wells to 100 feet. As reflected on Exhibit 8, and as addressed in paragraph 14 of Mr. Burns' declaration, prior to the entry of the 600-02 order, Newfield, OVINTIV's predecessor by name change and merger, drilled these wells. Sorry, I've lost my page here. Give me a second here. There's several wells listed there, 13 wells. They were all allocated on a wellbore basis pursuant to the rule of capture in the Cowling order. Once the 134 order was entered, it provides that those wells convert to the drilling unit basis effective the first of the month following the date of first production of the first long lateral horizontal well drilled. As outlined in the request for agency action and is shown on Exhibit 5, after the 139-134 order was entered, the Carl well was drilled, and therefore the conversion date was the first of the month. I believe that was July 1st that it converted. There are several parties. If you give me a second here, I apologize, Mr. Burke, Mr. Plaza. I'm on the page in my outline. I've got to make sure I've got them named.
I totally understand losing pages.
If you could give me just if we could walk on that for a minute.
Okay.
Armin, we're gonna
Go offline.
One.
And I apologize for the delay. Sorry, I've got my pages straight again. The Carl well, as shown on Exhibit 5, was drilled with first production from the U.S.M Butte member on June 13th, 2021. The conversion date, therefore, for the existing wells was July 1st of 2021. As shown on Exhibit 6, and addressed in paragraph 9 of Mr. Burns' declaration, there's 17 different oil and gas tracks in the drilling unit. Tracks 1, 12, and 16 are tribal acreage. As reflected on revised Exhibit 7, as addressed in paragraph 10 of Mr. Burns' declaration, Newfield was the majority working interest owner in this drilling unit, owning approximately 98.78%. And the parties whose aggregate gross working interest is 1.17% signed joint operating agreements, thereby voluntarily pooling their interest and which cover the consequences of their election with respect to the Carl well. There are 28 specific parties to be compulsory pooled and declared as non-consenting owners in the Carl well after the motion to amend, which I will address shortly. They are identified in pages 2 and 3 of the request and paragraphs 21 through 49 of Mr. Burns' declaration. In the interest of brevity, we ask that you take administrative notice of those portions of the pleadings already of record in lieu of reciting all those parties now.
Yes.
All right, as evidenced by exhibits 10 through 13, 18, 20, 21, 25, 26, 28, 32, 33, 35, 39, 40, 42, 43, 45, 46, 49, 50, and 55, and is addressed in the paragraphs of Mr. Burns' declaration relating to those exhibits. The requisite notice of opportunity to participate in the Carl well was provided and received by the parties identified therein, but none of them formally or timely responded. As evidenced by exhibits 17, 27, 29, 30, 34, 38, and 52, and is addressed in the paragraphs of Mr. Burns' declaration relating those exhibits, the parties identified therein, if known, were also sent the requisite notices of opportunity to participate to their last known addresses, but were returned to OVINTIV as either undeliverable or as refused. Pursuant to the board's order entered on January 27, 2025, all those remaining parties were also provided notice by publication in the Uinta Basin Standard on January 29th and February 5th, 2025, but again, none of them formally and timely responded. As addressed in paragraph 13 of Mr. Burns' declaration, since the filing of the request, the following parties who were named in the request to be compulsory pooled and declared as non-consenting owners have granted leases to OVINTIV. These parties are Amy Weiniger Embleton, Cindy Behunin Harper, David T. Losey, Deanne Losey Walk, Douglas Boyd Massey as personal representative of the estate of Ellen Louise Dennis Massey, Gayla Losey Kuhn, Glenn H. Losey, Harry Dean Weiniger, Brenda Pearson, personal representative of the estate of John Thomas Pearson, Kevin Behunin, Leonard P. Losey, Mary Losey, Mark A. Losey, Renee Weiniger Adams, Paul Wallace Weiniger, Stephen D. Losey, Sanderson Mineral LLC, and Tracy Behunin Bargerstock. As a consequence, OVINTIV moves to amend the request to eliminate them from being compulsory pooled in exhibits 9, 14, 16, 18, 19, 22 through 24, 31, 36, 37, 41, 44, 47, 48, 50, 52, and 54 are no longer required and will not be submitted for admission into evidence. And Julianne, for your sake, I will go over that very carefully at the end.
Thank you.
As a consequence, and is reflected in revised Exhibit 7, the aggregate gross working interest of the parties to be compulsory pooled in the drilling unit is 0.058510%. And you can see how many people we have involved here. All but a portion of which remain unleased, and also the remainder which represents Wenzel Energy's leasehold. That is a party who has a lease who has non-consented as well. In addition, although OVINTIV believes it has leased all of the successors, again, we have a list of decedents and estates who they're not complete probates or there hasn't been proper distribution. We're seeking compulsory pooling of any party claiming by through or under those estates that hasn't leased or is otherwise participating. Notice was published to them also in the Uinta Basin Standard on January 29th and February 5th, and no responses were received from those parties. I do have to clarify one of those decedents. As addressed in paragraph 51 of Mr. Burns' declaration, Mabel C. Naylor was one of the decedents originally named, but OVINTIV has discovered that her estate was in fact probated in Utah, and her duly confirmed successors are leased or are otherwise voluntarily pooled and participating in the Carl well. Consequently, we similarly would move to amend the request to eliminate her from the list of the decedents and the compulsory pooling of anybody claiming by through or under her estate. Replacement Exhibit 61 in this cause is a true and correct copy of the affidavit of publication received from the Uinta Basin Standard. As reflected on Exhibit 62 and paragraph 17 of Mr. Burns' declaration, and also is shown at the end of Exhibit 62, which I'll show here. The average weighted fee landowner royalty as of the date of the spud of the Carl well was 16.174186%. As outlined in paragraph 58 of Mr. Burns' declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the drilling unit. Their names and addresses were derived from a title opinion with an effective date of April 18th, 2023, as supplemented by a record search by OVINTIV's contract landmen and OVINTIV's internal records. As the record will reflect, none of the parties identified in the request is amended today as being compulsory pooled and or declared as non-consenting owners in this cause, timely filed a response or have made an appearance today. As a consequence, pursuant to Utah Administrative Code R641-104-150 and R641-108-400, OVINTIV moves to enter an order of default against them, and I would ask that the hearing examiner rule on that motion.
I rule affirmative.
Okay, thank you. As reflected in Exhibit 63 and as addressed in paragraphs 4 and 5 of Mr. Wall's declaration, the costs incurred in the drilling of the Carl well were reasonably and necessarily incurred and within reasonable variance of the AFE. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment costs for the well are $75,000. And finally, sorry, we don't have it that one there. There they are. As shown on exhibits 64 and 65, these are the risks that were outlined, incurred by OVINTIV at the time of the spud of the well, and also it addresses if there was any actual risk that they did incur in the drilling of the well. With that, I'll start my examination. Mr. Burns. Mr. Burns, please state your name and address, business address for the record.
Yes, Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
All right, what's your current position with OVINTIV and how does it relate to this drilling unit?
I'm a land advisor with responsibility over this drilling unit, among others.
All right, please state for the record the corporate bonding status of OVINTIV.
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production, Inc. And also just to address, as we did in the last hearing, on January 22nd, 2025, OVINTIV closed the sale of its Uinta Basin assets to 4 Point Resources, LLC, retroactively effective as of October 1st, 2024. However, Newfield and OVINTIV owned and operated the subject well at all times relevant to this cause, and as such remains the petitioner here.
All right, would you please confirm for the record that exhibits 3 through 8, 10 through 13, 15, 17, 20, 21, 25 through 30, 32 through 35, 38 through 40, 42, 43, 45, 46, 49, 51, 53, 55 through 60, and 62 submitted in this cause were prepared by you or OVINTIV personnel or contractors with your review and input?
Yes, they were.
Will you also confirm for the record that replacement exhibit 61 is an official business record of OVINTIV?
Yes.
All right, would you now confirm for the record that you have read and confirmed all the statements made in your declaration are true and correct? Or if you require any modifications, please state them on the record at this time.
Yes, I believe all correct with one change. Paragraph 54 should refer to both exhibits 59 and 60.
All right, is it your expert opinion then that the terms and conditions of the joint operating agreement submitted as exhibits 59 and 60 are fair and reasonable and consistent with those executed by the other working interest owners covering this drilling unit as outlined in paragraph 56 of your declaration?
Yes, I do.
These are also commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes.
Mr. Baza, that concludes my examination, Mr. Burns.
Very well. My question for Mr. Burns is, I know that as part of the records filed with this cause that, as Mr. McDonald mentioned, there were some objecting parties and you resolved those objections. I can't say that I understand specifically what their objections were. Some of it related to joint operating agreement, but could you summarize briefly how those objections were addressed and resolved?
Sure. I mean, honestly, I think it's just as a collective here, we see and read these RAAs and things on a daily basis almost. And to a mineral owner, there's a lot of legal jargon and, terms that are just, not very well understood. And so once we were able to speak with the three that had an objection and able to explain, exactly what we were trying to do and explain those terms and conditions of the JOA and what was in the request for agency action, their concerns were alleviated and they all three ended up leasing to OVINTIV late last week.
I did notice that. Thank you for that response. Division, do you have questions for this witness?
No questions. Thank you, Mr. Burns.
Thank you
Thank you.
much.
All right, thank you. With that, I'll commence my examination of Mr. Wall.
Thank you.
Mr. Wall, would you please state your name and business address for the record?
It's Christopher Wall, WOLL, business address of 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
All right, what's your current position with OVINTIV and how does it relate to this drilling unit at issue?
I am a reservoir engineering advisor with OVINTIV with jurisdiction over this DSU as well as others in the Uinta Basin.
All right, can you confirm for the record that exhibits 63 through 65, I'm showing them on the PowerPoint, were prepared by you or OVINTIV personnel with your review and input?
Yes.
All right, and can you confirm for the record that you have read and can confirm all the statements made in your declaration are true and correct? Or if you require any modifications, please state them on the record at this time.
Yes, and no corrections at this time.
All right, based on that, is it your expert opinion that the actual cost of the subject well at issue reflected in Exhibit 63 were fair, reasonably, and necessarily incurred?
Yes.
Is it also your expert opinion that the Carl 7H well was economically feasible to drill as that term is utilized in the 600-02 order?
Yes.
Finally, is it your expert opinion that the risks shown and outlined on Exhibits 64 and 65 justify the imposition of a 300% risk assessment award and are fair and reasonable under the circumstances of its drilling and operation?
Yes.
All right, with that, Mr. Bosler, that concludes my examination of Mr. Wall.
Okay, I don't have any questions for this division.
Thank you.
Okay, thank you much. So we're at the point now that we have to take closing statements from both the division and the petitioner. I'll start with the division.
Yes, thank you, Mr. Daza. The division has reviewed the request for agency action and the exhibits and has no objection to this request being granted by the board.
Thank you very much. Mr. McDonald.
Thank you, Mr. Bosler. Julianne, make sure I've got these right, okay? I'm going to move for admission of exhibits 1 through 6, revised exhibit 7, exhibits 8, 10 through 13, 15, 17, 20, 21, 25 through 30, 32 through 35, 38 through 40, 42, 43, 45, 46, 49, 51, 53, 55 through 60, replacement exhibit 61, and exhibits 62 through 66, as well as Mr. Burns and Mr. Wall's declaration.
Yes, so admitted.
Thank you. With that, Mr. Bazo, we believe that all the statutory and regulatory requirements have been satisfied, that the requested relief is fair, reasonably justified, and we ask that you make findings and conclusions supporting the granting of the request as submitted. We also like to thank you especially for your time and also to the IT people at the DNR building for allowing the virtual participation.
I should have asked the division, do you object to any of those exhibits?
Oh, yeah.
No objection.
Okay, thank you. And they are.
Thank
you. All right. My thanks go to the IT staff as well. It's one of those things that always has its little quirks and disruptions, but I managed to work us through it quite well. Thanks, Carmen. So having reviewed the request for agency action, all the exhibits and the evidence and testimony presented today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present at these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that it's entitled to forced pooling of the named interest and other relief requested in the request for agency action. And I'm prepared to present these findings and conclusions to the board next week. So Mr. McDonald, would you prepare a proposed order and prepare for the board meeting next week?
Certainly, Mr. President, I'll be happy to submit that to council, your council, and the division's council ahead of time.
So any other comments? If not, I thank everyone for their patience and participation today, and we'll adjourn this proceeding. Thank you.
Thanks.
Thank you all.
So,
1.
Morning, everyone. Welcome. My name is Gary White. I am an Assistant Attorney General, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, February 19th, 2025. This is the time and place for the hearing examiner's proceeding for docket number 2025-016, cause number 132-73, in the matter of the request for agency action of OVINTIV USA Inc. for an order modifying the board's order entered in cause number 139-118 to declare certain parties as non-consenting owners in the ranch 15-10-3-3-2W-MW and the Ute Tribal 14-10-3-3-2W-MW wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formations, comprised of all of sections 3 and 10, Township 3 South, Range 2 West, U.S.M, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources Resource Building in Salt Lake City, Utah. Before we begin, are there any members of the public or respondents present that wish to comment in these proceedings? Doesn't appear there's anyone in the room. Is there anyone online? No. All right, thank you. Let the record reflect that no public, members of the public or respondents are present. I'll take appearances of counsel at this time.
Fred McDonald of counsel with Lear and Lear on behalf of petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Before we begin Mr. McDonald's presentation, some housekeeping items. I've received the declarations from Mr. David Dale and Mr. Christopher Wool, who are with us today, and I have reviewed those declarations prior to this proceeding. Does the division have any objections to these declarants or their declarations today?
No objection.
Any concern about these witnesses being qualified as experts?
No.
All right, they will therefore be recognized as experts in their particular fields of expertise for this matter. And Mr. McDonald, it appears that these two witnesses are present today. Any other witnesses that you intend to call?
No, these two are the only two.
All right. If I could have each of you raise your right hands, we'll get you sworn in. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
For the record, the witnesses have affirmed yes to the previous statement and are now sworn in. Mr. McDonald, please go ahead with your presentation.
Great. Thank you, Mr. White. Just for the record, again, Mr. Dale is being recognized as an expert in petroleum land management for purposes of this cause, and Mr. Wall is being recognized as an expert in petroleum engineering. I want to confirm that you received the supplement to Exhibit 19 submitted yesterday. That's simply the status of the certified mailings to the compulsory pool party.
I believe we did. Division, did you receive that as well?
Yeah.
Thank
Right.
you.
And secondly, last night I filed a supplement to Exhibit 2, which is the joint operating agreement that was supposedly imposed under the terms of the 139-118 order. It was not found with the order online. You had to separately go into that matter number and pull it. And I'm going to be filing that as a supplement to Exhibit 2 so that a complete copy of the 139-118 order is part of the record.
That would be great. Thank you.
All right. The board, and by designation, Mr. White as the hearing examiner, has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations at R641-2-8A and 9A. A copy of the request was mailed certified mail to the known party sought to be compulsory pool and mailed regular mail to all of the production interest owners in the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. Due to their respective ownership in the drilling unit, it was also included in the mailing was to the Ute Indian Tribe, the Ute Distribution Corporation, Bureau of Indian Affairs, Vernal Field Office of the Bureau of Land Management due to tribal mineral ownership, and also to the School and Institutional Trust Lands Administration due to state mineral ownership within the drilling unit. In addition, the notice of the filing of the request and the hearing was also duly published in the Uinta Basin Standard on January 29th, 2025, and then the Salt Lake Tribune on February 2nd, 2025. On February 10th, 2025, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request. One other party, Connie Wright, did file a timely objection, but she has formally withdrawn that objection after consultation with OVINTIV's land broker and myself clarifying her status. No other objections or responses to the request for timely filing. To summarize this matter, this cause involves the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 3 and 10, Township 3 South, Range 2 West in Duchesne County. Exhibit 4 reflects that section 3 is an irregular section comprised of 4 lots along the north half, the section comprising a total of 645.24 acres. Since section 10 is a regular governmental section, the drilling unit is actually comprised of 1,285.24 acres. As shown on exhibit 3, the drilling unit is approximately 2.5 miles northwest of the Mighton town site in Duchesne County. The drilling unit was originally established on a pilot basis for Upper Wasatch production by the board's order entered in cause number 139-110, as modified by the board's order in cause number 139-117. It was similarly established on a pilot basis for U.S.M Butte production by the board's order on cause number 139-113. All of these orders were subsequently vacated and superseded by the board's order entered in cause number 139-134, which established the drilling unit for the entirety of the Lower Green River and Wasatch Formation. A true and correct copy of the 139-134 order was submitted as part of Exhibit 2 in this cause. It outlines the history of these pilot orders in detail. As reflected on Exhibit 8, in paragraphs 12 through 17 of Mr. Dale's declaration, Newfield drilled and OVINTIV operated 4 wells on the drilling unit. 2 of these wells are the Ranch 16 well, drilled pursuant to the 139-110 order with first production from the Upper Wasatch on June 30th, 2014. Secondly, the U.S.M 13 well was drilled pursuant to the 139-113 order with first production from the U.S.M Butte on February 24th, 2015. Pursuant to the board's order entered in cause number 139-118, the board compulsory pooled all interest in the drilling units established under the 139-110 and 139-13 orders and declared certain parties as non-consenting owners in the Ranch 16 and the Ute Tribal 13 wells. Neither of those wells has reached 100% payout. A true and correct copy of the 139-118 order was submitted as the remainder of Exhibit 2 in this cause, and as I previously mentioned, the joint operating agreement imposed under that 139-118 order has been submitted as a supplement to Exhibit 2 today. As reflected in both Exhibits 5 and 8, and as outlined in paragraph 18 of Mr. Dale's declaration, Newfield also drilled and OVINTIV operated the Ranch 15 and the Ute Tribal 14 wells, the 2 wells at issue today, as Upper Wasatch wells in accordance with the 139-110 order as modified by the 139-117 order. The Ute Tribal 14 well began production on February 22nd, 2015, while the Ranch 15 well began production a day later. Neither well has achieved the 100% payout yet. However, as addressed in paragraphs 19 and 20 of Mr. Dale's declaration, and for some unknown reason, the 139-118 order neither addressed nor was subsequently modified to address the Ranch 15 and Ute Tribal 14 wells. Furthermore, the 139-134 order neither addresses the 139-118 order nor the Ranch 15 and Ute Tribal 14 wells. This is why OVINTIV has initiated this cause to remedy those omissions. As reflected on Exhibit 6 and in paragraph 9 of Mr. Dale's declaration, there are 18 different oil and gas tracks within this drilling unit. Track 7 is the Sitla tract, while track 18 is the tribal tract. As reflected on Exhibit 7 and is addressed in paragraph 10 of Mr. Dale's declaration, Newfield and later OVINTIV was the majority working interest owner in the drilling unit at approximately 85.7%. 4 other parties whose aggregate working interest is 13.9% are subject to joint operating agreements, thereby voluntarily pooling their interests and which govern the consequences of their elections as to the wells at issue. As evidenced by exhibits 9 through 12 and paragraphs 21 and 22 of Mr. Dale's declaration, Michael Lynn McCarroll owns an unleased undivided oil and gas interest, which equates to the remaining 0.4% gross working interest in the drilling unit. He was provided the requisite notices of opportunity to participate in the Ranch 15 and U Tribal 14 wells, but failed to timely and formally respond. In addition, although OVINTIV believes it has all the parties leased, there are decedents out there that have estates that haven't been probated or properly distributed, and therefore we are also seeking to compulsory pool any party claiming buy-through under those estates that isn't already leased or is otherwise participating in the well. Pursuant to the board's order entered on January 27, 2025, the requisite notices of opportunity to participate were provided to them by publication in the Uinta Basin Standard on January 29th and February 5th, 2025. Again, no responses to those published notices were received. Replacement Exhibit 13 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibits 14, and I'm going to turn to the last page, in Exhibit 15, the average weighted fee landowner's royalty as of the date of spud of the U Tribal 14 well was 16.858826%, and the Ranch 15 well was 16.858810%. As outlined in paragraph 29 of Mr. Dale's declaration, the parties shown on the certificate of service filed in this cause are all the production interest owners in the drilling unit. Their names and addresses were derived from title opinions with effective dates of January 4th, 2012 as to Section 3 and December 28th, 2011 as to Section 10, as supplemented by a record search by OVINTIV's contract landmen and OVINTIV's internal records. As the record will reflect, one of the parties identified in the request as being compulsory pooled and or declared as non-consenting owners in this cause timely filed a response or made an appearance today. Consequently, pursuant to Utah Administrative Code R641-113-100 and R641-108-400, OVINTIV moves to enter an order of default against him, and I ask that the hearing examiner rule on that.
Commission, any objection?
No objection, no.
Granted.
Thank you. As reflected in Exhibit 16, paragraphs 4 and 5 of Mr. Wall's declaration, the cost incurred in the drilling of the Ranch 15 and U Tribal 14 wells were reasonably and necessarily incurred and within reasonable variance of the AFEs, especially given the difficulties incurred in their drilling, which is shown on the following exhibit. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment costs is $75,000. Finally, on exhibits 17 and 18, and as outlined in paragraph 7 and 8 of Mr. Wall's declaration, the risks assumed at the time of the spud of each of the wells are shown, and the actual difficulties incurred in their drilling are also addressed in these exhibits. With that, I'll commence my examination of Mr. Dale. Mr. Dale, would you please state your name and business address for the record?
Yes. David Dale with OVINTIV, 4 Waterway Square, Suite 100, Woodlands, Texas, zip code 77380.
And what's your current position with OVINTIV, and how does it relate to this drilling unit at issue?
Yes, manager of Rockies Land, which is over our Uinta Basin assets.
Including this drilling unit, correct?
Yes.
All right. Would you please state for the record the corporate and binding status?
Sorry, yes. Sorry, Fred, I got to go to it. Make sure I say it right. Yes, OVINTIV is a Delaware corporation in good standing with the principal place of business in the Woodlands, Texas. It is duly authorized to conduct business in Utah and fully bonded with all appropriate federal and state agencies.
All right. Would you just again, for the record, and just advise the hearing examiner and the division, what's the current status with respect to these Uinta Basin assets from OVINTIV? They recently divested, correct?
Yes, that is correct. On January 2nd of this year, we closed on the sale of this basin to 4 Point Resources LLC. It's retroactively effective October 1st of 2024. However, Newfield and OVINTIV own and operate the subject wells at all times relevant to this case, and as such, OVINTIV remains the petitioner.
All right, would you confirm for the record that exhibits 3 through 12, 14, and 15 were prepared by you or OVINTIV personnel or contractors with your review and input?
They were?
And is replacement exhibit 13 an official business record of OVINTIV?
Yes.
All right, can you confirm for the record that you've read and confirmed all the statements made in your declaration are true and correct? Or if you require any modifications, please state them at this time.
They're right.
Okay, the division informally requested an explanation as to why OVINTIV seeks to replace the joint operating agreement adopted with the 139-118 order with the joint operating agreement that we submitted as Exhibit 12. Can you kind of outline the differences between the two joint operating agreements and tell why OVINTIV would like the latter to be adopted?
Yes, the forms are substantially the same. There's minor alterations as it pertains to liens or taxes, as well as the gas balancing and fees associated with the marketing contracts. But they're by all intent and purpose, the same form.
So essentially what you want to do is get the joint operating agreement consistent with what most of the joint operating agreements are throughout the rest of the basin?
That's correct, yes.
So your expert opinion that the terms and conditions of the joint operating agreement submitted as Exhibit 12 are fair and reasonable and consistent with that executed by the other working interest owners covering this drilling unit as outlined in paragraph 26 declaration?
Yes.
And also that those terms are commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
And it's also your expert opinion that Exhibit 12 is necessary to replace the joint operating agreement submitted as a supplement to Exhibit 2 from the 139-118 order, right? For the reasons you just addressed.
Yes.
That concludes my examination, Mr. Deal.
Mr. Haynes?
I just have a couple of questions, Mr. Dale. Let's just go back to the JOA really quick. Let me find. You mentioned the gas balancing change. I believe, let me pull it up. Well, I'm trying to find it. I believe in the original, the selection in the JOA was no gas balancing agreement, and now it's being switched to having a gas balancing agreement. Could you just explain what that would mean to one of these the non-party?
Yeah, the purpose of the gas balancing agreement is essentially like if parties are able to take their share of gas to market, if they have markets in place, and other parties perhaps would not have a market, it allows for certain parties to be overproduced as to their quantum of gas and other parties to be underproduced. And then how that gets balanced in the future. So that is to say, if a party was unable to sell their gas at one point in time, it would let the other operators sell that quantum of gas. And then the party that wasn't able to sell, once they do secure a market, they could then sell, not only the current share, but the past share that they're actually due and make it up from the previous imbalance.
Okay. So these lands were previously pooled under prior orders. There was three, I think, deceased parties in that prior order. Now we just have the one party that remains unleased. Michael Lynn McCarroll is the one party that we have left. I noticed that in your affidavit, it was indicated that an offer to lease was sent out, but there's been no response. Since these wells were drilled in 2014 and we moved forward, could you just explain where did their address come from? How are we assured that this is the most recent address that you were able to access? I guess is where I'm getting at, because I mean, this is a 2014 title opinion moving forward.
That's right. So, I mean, generally where we start is the last known address of record within the county records. And as you mentioned, if there's no documents post 2014, there's nothing at the county records that we can rely on. So we use multiple different services, search records, peoplefinders.com, ancestry.com, various other means to try to gather information, as well as reaching out to who we believe could be relatives. And that's very common in Utah. When you have airship, if you can't find a cousin, but you know you've leased others, sometimes family members can be very helpful to locate people, or at least get a good address. But we do a diligent effort. Probably, frankly, I feel like our broker, Lone Wolf Energy, probably goes above and beyond what is required to find these people. You know, in many cases on these, we start these poolings, and we can be search and notice for 6 months before we actually file. So it's a pretty diligent effort to hunt them down.
All right, thank you. And just making sure I had no more questions. Nope, that's all I have for Mr. Dale. Thank you.
Mr. Dale, just one question and follow up to the replacement JOA that's been submitted as Exhibit 12. Does that only apply to Mr. McCarroll, or does that retroactively apply to everyone who's been compulsory pooled? Does that make sense? Because I know there were some poolings before.
It does, and I'll answer this. However, I'm also going to defer to Fred to help me understand how the mechanics of it would work with this particular application. But I believe it does supersede and replace the previous JOA. Is that correct, Fred?
Yes, that's the intent.
For all pooled.
Right.
Yes.
Okay. Thank you. I just want to make sure I understood.
Yes.
Actually, I apologize. I did have a question. I
That's
was
fine.
trying to remember what it was that it came to me when you were talking. And maybe this is a question for Mr. Dale or you, Fred. Could you just explain to me, okay, so here's this party. We have one party left. We're going to allow him to have a royalty share if this is granted. What from the time these wells went into production to now, where has his interest? What has happened with his interest or his share of proceeds of production?
Yes. So essentially, unidentified owners, that revenue interest gets put in suspense. Now, the working interest cost side responsible for that is borne 100% by OVINTIV. We could not find him. We had no means to force an election. So we're paying for his share. So that money gets put in suspense, and every state's different. But after it sits in suspense for a period of time, it eventually gets escheated to the state. Now that owner can go to the state and claim that money. But until that happens, it's just an unclaimed interest that goes to the state. And ultimately, I mean, to piggyback on Fred's point, the reality is we spend a lot of time researching who these owners are, how we can locate them. If we could lease everyone, it would sure save us all a whole lot of time and effort on these hearings. Unfortunately, that's just not always the case. And so we do our best to locate them and give them the opportunity to participate. But at the end of the day, it is their responsibility, to manage their own assets, to be locatable, to respond to mail. They're out nothing in this situation because we bore 100% of the costs, and they're able to go get the revenue that's their share from the state at a time of their choosing.
So as it stands right now, though, this party, they would have a suspended amount in your system.
That's correct. But the actual funds themselves have been sent to the state of Utah.
Yeah, they hold it
okay.
in suspense for the period of time under the unclaimed. So like if it's a Utah resident, after 3 years, then they turn it over to the unclaimed property.
Oh, okay. So that would have already happened with this
right.
party.
Yeah.
Okay, that's good to know.
Yeah. Fred had a much more succinct answer than I did there, Andrew.
I was just curious how that was treated in your system, and thank you for clarifying that. I was not aware that that would have already happened with their unclaimed amount. All right, thank you.
We good then?
Yes.
Okay.
Go ahead.
Commence my examination, Mr. Wall now. Thank you, David. Mr. Wall, would you please state your name and business address for the record?
Yes, Christopher Wall, WOLL, 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what's your current position with OVINTIV and how does it relate to this drilling unit at issue?
I am a reservoir engineering advisor with OVINTIV with jurisdiction over this GSU as well as others in the Uinta Basin.
All right, can you confirm for the record that exhibits 16 through 18 were prepared by you or OVINTIV personnel with your review and input?
Yes.
And you also confirm for the record that you have read and can confirm that all the statements made in your declaration are true and correct, or if you require any modifications, state them at this time, please.
They are correct and do not require any modifications at this time.
Okay, is it your expert opinion then the actual cost of the Ranch 15 and the Ute Tribal 14 wells at issue reflected in Exhibit 16 were fair, reasonably, and necessarily incurred?
Yes.
But also your expert opinion that those 2 wells were economically feasible to drill as those terms are utilized in the 139-110 order, as well as the 139-134 order.
Yes.
Finally, is it your expert opinion that the risks shown and outlined on Exhibits 17 and 18 justify the imposition of a 300% risk assessment award, and that it's fair and reasonable under the circumstances of their drilling?
Yes.
All right, that concludes my examination, Mr. Wall.
Mr. Haynes.
No questions, Mr. Wall.
All right, and I have no questions. Mr. McDonald. Well, actually, let's start with the division for any closing remarks.
Thank you. As we indicated in our response that we filed, the division does not have opposition to this request. 2 points that we pointed out in our response, just to be aware of, was the objection by Connie Wright, which has been resolved, and was the adoption of a new JOA. But in as much as no parties have objected and that we're having a hearing on adopting these new terms, the division has no objections to that either.
Thank you. Mr. McDonald, closing remarks, please.
Thank you. First of all, let's move for exhibits, initiative exhibits 1, 2 is supplemented, 3 through 12, replacement exhibit 13, and exhibits 14 through 19 is supplemented, as well as Mr. Dale and Mr. Wall's declarations.
Any objection? So admitted.
All right. With that, again, it's kind of strange that they went through a forced pooling hearing for 2 wells when the other 2 wells were either drilling or had been drilled at that time. Can't explain why. Tom Clausen's long time retired. I don't know why. But again, in an attempt to try and get everything cleared up and ready to go, OVINTIV has made this effort. I think the regulatory and statutory requirements have been satisfied. We would ask that you, as the hearing examiner, provide the findings and conclusions of law that would support the granting of this request by the board next week. thank you certainly for your time and effort, and Mr. Haynes, and as well as the DNR IT people for allowing your virtual participation by our witnesses today.
Thank you, Mr. McDonald. Having reviewed the request for agency action, the exhibits submitted, and having considered the evidence presented here today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting CP owners, and that those owners identified in the RAA did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. Finally, I find that OVINTIV has met its burden of proof to show that they are entitled to forced pooling of the named interests and other relief requested in the RAA, including the replacement of the prior JOA with the version submitted as Exhibit 12. Mr. McDonald, will you prepare the proposed findings, conclusions, and order?
Certainly, and I'll submit them to you, Mr. Haynes, in time for review and comment before the hearing next week.
Excellent. Given no objection by the division, I'll present those findings and conclusions to the board next week. And unless there are any questions or comments, I think we're adjourned.
Thanks, everybody.
Thank you, everyone.
Thank you.